Jefferson County Court at Law number 2 is back in session. Court is in session in cause number 326546. The case is styled the state of Texas versus Adam Anthony Whitfield. Mr. Whitfield, would you please raise your right hand?
Yes.
Mr. Whitfield, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Whitfield, you may put your hand down. How are you doing, Mr. Whitfield?
I'm pretty good, sir. Bless.
That's good. Now, Mr. Whitfield, I have before me a document. Well, first, Mr. Whitfield, I have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
Now, on page 2 of this same document, there is a signature above the line that's titled Defendant Signature.
Yes.
Is this your signature?
Yes, sir. Yes.
I also have a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that is titled Defendant?
Yes, sir.
And are these your initials on the line stating that you would like to apply for a court-appointed attorney?
Yes, sir.
Now, Mr. Whitfield, before you signed and initialed these documents, did you read the documents?
Yes, sir. You went over.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
To the best of my knowledge, I guess, sir. Yes.
Okay, now, Mr. Whitfield, let me do this here. Now, pursuant to Article 1.24 Texas Code of Criminal Procedure, all proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365, Southwest 321, the right to a public trial is not absolute, and it may be outweighed by other competing interests, such as interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. Now, I'm going to ask you some questions regarding your affidavit of indigence. And in this document, obviously, that's your financial information, et cetera. And that information is non-public. It's your private information. Now, if you desire, the court can, you can request that this proceeding be closed to the public, because actually we are airing on YouTube.
Yes.
And after the public has access to it. And so you could request that this hearing be closed to the public. And by doing so, if the court grants that, then we will turn the YouTube off.
If I could, yes, sir.
You would like to do that? Okay, so the court finds that the party seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced to him, that it would disclose non-public information, and the closure is no broader than necessary to protect his interests. The court have considered reasonable alternatives to closing the proceeding, and the court make these findings, and these findings are adequate for the closure of this hearing. And at this time, this proceeding will be closed to the public.